lawyer for Roxy Nelson Eche Dafeamekpor. His case was thrown out today. Nipakwa has joined us on the line. Counsel, you're welcome to Eyewitness News.
Yes, Umaru Sanda.
Umaru
Sanda, how are you?
I'm fine, thank you.
And please, it was an application that was dismissed. His case was not thrown out.
Yeah, but the application itself is also a case. You've gone to make a case.
Umaru, the application is not a case.
It's an application making a case that something should not be done or something should be done, and that case has been thrown out.
English semantics. My good friend, let's go.
Okay, why did you run away from your own case, by the way?
We didn't run away from our own case.
The Supreme Court, in fact, the Chief Justice was chairing the panel. They looked for you left, right, center in the courtroom. You were nowhere to be found. You brought your case and you were nowhere to be found. That's what the Attorney General said, that you fled from your own case. What happened?
We didn't flee from our own case. We are supposed to be served with a hearing notice on the date that has been called by the court. So I received a call from the bailiff of the court that he had a process for me. Unfortunately, yesterday I wasn't in Accra, and I want to get the correct time so that I have exactly my time. He called me at exactly 10:50 a.m. So I informed him that I wasn't around, but I was going to give him the number of the plaintiff so that he could serve the plaintiff with the hearing notice or whatever documents he had, which was, so I sent him the number at 10:57. He acknowledged receipt and said, receive with thanks. That was the last time I dealt with the said bailiff. I was therefore very surprised to hear today that this bailiff alleged that he walked into my office and I had left an instruction, or he was reported to have been told by front desk people that I had left a specific instruction that no process was to be received. And when I did an official search, he said, in that particular case, for him, perhaps he didn't know. We have a CCTV system in this place that has an audio capability. So I have released the CCTV video footage and the audio of his interaction with my front desk. And I've sent it to you. You can play it for the whole world to hear. Whether anyone at the front desk ever said what he said, that was a complete and barefaced lie. What he did was he came in and identified himself as a bailiff and that he had a process. He placed the process on the table and the clerk or the front desk person saw my name on it and said, oh, my boss is not in at the moment. Can you wait so that when he comes, he receives this process and signs for it? He said he was making a phone call to ascertain whether that should be the procedure that he should go by. He informed the front desk people that he was coming, in that he was making a phone call and that he will return. And he disappeared. And so you can watch the footage for yourself. It has an audio on it. Listen to the interaction and judge for yourself.
Okay, I think
whether anybody in the front desk ever stated the very thing that he went to say in court today. But be that as it may, the Supreme Court has said that once he left the process on our table, it constitutes service. We have no argument with that. The court has gone ahead to make a decision on our injunction application. We are okay. We have also filed the substantive case is still pending. We'll wait for the court to call us on that one. We'll go and attend to it. Also, we have a mandamus application coming up in the High Court on the 8th in respect of the LGBTI matter. So we have moved on and we are focused on that one whilst we wait for the substantive case to be called. We have had our day in court. The court has ruled. That is all that you can do as a citizen of the country.
Okay, I'm yet to receive the video you said you sent. Yes, because you advertised that you sent it to me.
Fred has it. If you ask Fred,
okay, that's fine. Just for the record, since you've advertised that you're giving it to me, I have to issue a disclaimer.
Sorry,
it's fine. It's fine. So the bailiff did not contact your client, did he, to try and do the service on him?
I cannot tell. That is the surprising part, because at least I have the text message interaction, and I have also screenshot that and sent it to Fred, and the exact times are there. So when I did the search, I conducted an official search today, and I'll send that also to. Clearly, I wasn't served personally, my client wasn't served personally, but he makes an allegation that at the front desk of my office, this was what he was told. It is a barefaced lie. And perhaps he didn't know that we had a CCTV capacity that also had an audio recording. Be that as it may, once he left the process, the court says it's proper service. So we went ahead. That's it.
But you couldn't get to argue why the injunction should hold. It was
that's the thing, because we didn't have the benefits of the hearing notice, because I never stepped in the office unfortunately yesterday, so I didn't have the benefits of. But that is it's done. So once it's done, you can't.
So your reason for not showing up today is that you did not know you were supposed to show up today.
I don't, because I wasn't there.
But it was public knowledge that your case was being called today. In fact, the NDC issued a statement.
Really?
The NDC issued a statement complaining as to why your case was being listed today when Richard Sky's case, which was earlier.
Unfortunately, I'm not a member of the NDC, so I wouldn't know.
No, there's a press statement which is a public document that has been circulated, so everybody knows that today you are supposed to be in court. That's why.
If you notice, the past 3 or 4 days, I've been working back and forth to get my processes passed. So, unfortunately, I've had very little sleep. So yesterday, after my surgeon out of Accra, I came back and went straight to bed. But on this, the court has already determined. So what can we do? It's done.
Now, the substantive case itself is where. So this was an injunction trying to prevent
Parliament. An injunction to restrain Parliament from going ahead with the. And also, I need to. We have filed 2 injunction applications. One, we were intending to withdraw. If I was there, we were withdrawn the first one and dealt with the second one. So, of course, the court felt we had repeated the same document twice. But there was a difference because there was a second relief on the second document. But, of course, the court then decided that it was a duplicitous application. So it would strike the second one out for being a duplicity of the first. But the reason was that we were going to withdraw the first one and continue with the second one.
What would be the use of the main case, though? Because the horses would have bolted, and what I mean is that the House of Parliament would have made a determination already. So, what's the point of proceeding with the main case?
Parliament has not adopted any report. You understand? Parliament has not adopted any report. Parliament had not laid any report. So the process was ongoing. See, what we were simply saying was that everybody on that list, there were 3 categories. They came on one composite list. One, the A part were the people who had been removed from office and who we say should have been represented to Parliament for approval. The B section was the new minister. The argument of the issue was that these new people should not be affected by the rate ongoing. And then the C column had to do with those we said should be part of the list that were going for vetting. So our point was that the list that has come out with the schedule for vetting did not include those people who had to be approved by Parliament because they had been removed from office. So we didn't want Parliament to be aiding, in our opinion, the executive to breach the law. But the Supreme Court says no. When Parliament is in the process of doing its work, you can't injunct it. Yes, we'll hear your substantive matter, but allow Parliament the freedom to do its work. So that is the decision of the court. Which
means that so the main arguments are yet to come. Do you know when that would happen?
Yes, of course. The main case itself is still yet to be determined.
Have you been given a date on when that would be heard?
No. That's always at the discretion of the court.
Okay. What do you make of this statement made by the NDC that there appears to be some selectivity in listing cases? You have been working in the court system for many years. How are cases listed, and must a case
entirely within the judicial registry? We have absolutely no power over how cases are listed. So this question is best suited for the judicial secretary or the registrar of the court. We have no power and of course, but today I think that Attorney General gave a hint that he applied for expedited hearing of the matter. So maybe the parties in those other cases that were mentioned should also file expedited hearing applications and see whether they will be granted. Then we move.
Very well.
We have done so in the mandamus. The original date for the mandamus application was the 15th. We filed an application for abridgment of time, and the court has granted us that request, the register. So we are actually doing court on the 8th of April to hear the mandamus application, which is to compel the president to receive the bill from the speaker. So if you make the application, it is likely that it will be granted. So it is up to the parties if they are interested. Because if you file the case, one would wonder why you would want to, since you filed the case, you wouldn't want the matter to move. Unless, of course, you filed the case for an ulterior motive. So I think you should be directing this question to your colleague Richard Sky and anybody else who has filed a case in court as to why they are not pushing their case forward.
Very well. Thank you. Thank you so much, Nikpakpor. And please do send the video. I'm yet to see it.
Just with Fred, please. Check with Fred.
Okay, I cannot reach him. He's not available currently.
Okay, then let me send it directly to you.
Yes, please do that so that we can,
Right,
because you mentioned it is only fair to let our listeners know.
No, it's also fair to you, yes, definitely.
Merci beaucoup. That's Nikpakpor Samuel Addo. He's lawyer for Roxy Nelson Eche Dafeamekpor, member of parliament, who has brought that application. He has a case and also an injunction application that the House of Parliament should not go ahead and approve President Akufo-Addo's nominees. This is because in the communication to